Okay, part three. Part three. I told you about the warrants and I read what was missing constitutionally that would not give the judge the power to even sign this warrant without breaking the law himself, acting as a rubber stamp, meaning working in the favor of the police. And if you look up the laws of canon, as a clear violation of the laws of canon. Now, I wrote, like I said, I put in complaints with the South Carolina Bar Association, the Disciplinary Council, and everything that I put down, it was shot down. Even based on the facts that I sent them. I sent paperwork from them. None of this is stuff that I'm making up. Even when I say the lack thereof for this warrant to make it even give the judge authority, everything constitutionally needed for the judge to sign this warrant is lacking. Yet, they say the judge still signed it. Not only did he sign this, they said he signed multiple copies of the same warrant. And this is the Ninth Circuit Solicitor's Office under the leadership of Scarlett Wilson. Now, I got this on 3 transcripts, not 1, 3 transcripts with them saying that it's okay for a judge to sign multiple copies of the same search warrant. Search warrant wasn't changed or modified, wasn't for another search. The search was already completed, so you couldn't change it after they came in the house and they left the original. This is the original. Without this original, because this should be a copy of this, had they got it like they're supposed to, because you're supposed to go to the judge, get the signature, make copies, and give copy to the person that you serve. So there could be no explanation for why the signatures on this warrant that was served at my house and left at my house doesn't match this one. Exactly match. A copy, you go to your Xerox, you put something in the Xerox machine, and you make a copy of it, the color should be the only thing that changed. Nothing about it else should change. If it does, it is not a copy. Look up the Black's Law definition of a copy. Also look up the best evidence rule, which would be in that definition, the best evidence rule when it comes to copy. And I'll read out copy, the definition of Black's Law for copy. A transcript, a double imitation, or reproduction of an original writing. What is an original writing? Wouldn't that be a signature? Okay, a picture, instrument, or like thereof. Under the best evidence rule, a copy may not be introduced until the original is accounted for. Certified copies are admissible under statute in most jurisdictions. Similarities, photographic copies, and prints from photographic film are admissible by statute. Copies of all pleadings, motions, and other papers must be served to all parties to the action under federal or civil P.5 D. Now, mind you, in that definition, it says original writing. That would be a signature. So explain how this warrant was served, left at the house, and it doesn't match the one on the file of the Ninth Circuit or the solicitor's office, because the solicitor gets all their stuff. And I went several times to ask. I did several freedom. I got all this on record. I got a paper trail so heavy you can't get around it. Now the problem is coming with, I fought this in the lower court. I did, when I went to prison, I did a motion for new trial. I got denied without a factual basis, which the law requires that the judge give you a factual basis why your case wouldn't be overturned. Now the second motion I put in for new trial, the same pleading judge, which should have been automatically excusing herself, they call it recusal from the case, did not recuse herself. She actually denied my second motion. That's on record. And she took it personal with the letter that I wrote with it, so she refused it, which allowed me to get appeal because I established prejudice. She knew the rules and she broke them because she felt some kind of way without giving me my appeal. And I got out of the lower courts and went to the appeals court. I filed an appeal in a PCR hearing right when I found out everything was going on. So I gave them a choice. They gave me a choice. But they had to either give me an appeal or a PCR hearing. Now, on part 4, I'm going to explain to you what happened in the PCR hearing or the appeal. So stay tuned.